Hello everyone. We've reached day 6 of the hearings in the challenges to the abrogation of Article 370, and here's what happened today. Senior Advocate Rajeev Dhavan argued on how the Constitution recognizes and engages with different realities in different states and offers bespoke solutions. India's social, political, economic, cultural diversity often means that some states need different rules and frameworks to govern them. Article 370 and the unique framework in which the Indian Constitution applies to Jammu and Kashmir, he argued, is one such framework. In 1954, Presidential Order CO 48 had made most of the Constitution apply to Jammu and Kashmir, with some modifications and exceptions. One such provision was Article 3 of the Constitution of India, which concerns formation of new states and alteration of areas, boundaries, or the naming of states. Now, this Presidential Order CO 48 made a modification to Article 3 and stated that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. At that time, because Jammu and Kashmir was under President's rule under Article 356, instead of the state legislature, Parliament gave consent. Dhawan argued that this process set for Jammu and Kashmir cannot be substituted by using a proclamation under Article 356, which is President's rule. He insisted that circumventing the conditions around Article 3 using the President's rule has the effect of a constitutional amendment, and this was a gross subversion of the Constitution. At this stage, Chief Justice D.Y. Chandrachud asked, "Does this mean that while the President may exercise the power of a governor and Parliament that of the state legislature under President's rule, they cannot exercise powers under certain provisions like Article 3 and 370? Dhawan responded that the powers under Article 356 are not absolute. He focused on the process and the procedure followed to exercise the powers under Article 356. He said the President's rule certainly does not grant power to amend the Constitution or deprive it of its mandatory processes. Now, coming back to his argument on a diverse India needing diverse solutions, Dhawan patiently took the court through a list of provisions in the Constitution that gave effect to the unique needs of people in different areas. For instance, Article 164 appoints a minister in Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha to govern the welfare of scheduled castes and other backward classes to respect the distinct demographic needs of those states. Article 239A and 239AA are special provisions for Pondicherry and the NCT of Delhi. Article 244A allows for the creation of an autonomous state within Assam in certain tribal areas. This autonomy, Dhawan argued, was fundamental to our Constitution. He submitted that these special provisions were a regular feature of the Constitution, which enabled the needs of SC, ST, and OBC communities and localities of various backgrounds to be represented in the democratic fabric of India. All these provisions, Dhawan argued, were facets of a multi-symmetric federalism. This was crucial to our Constitution and could not be done away with by executive orders. Arguments in the second half of the day were made by Senior Advocate Dushyant Dave. His main argument was that the two presidential orders of 2019 were abuses of constitutional mandates under Article 370. This argument follows the line of the arguments made previously from the petitioner's side. The laws made during a president's rule, Dave argued, were limited just to that period. They could not amend permanent provisions of the Constitution indefinitely. Therefore, the President could not abrogate Article 370 when the state was under President's rule. Dave then pointed out that the Union's justification of the abrogation was national interest. However, the Union had not described what this interest was. He argued that an arbitrary exercise of powers could be a serious breach of democracy. The many days and many arguments in the hearing seemed to weigh on the bench. They were seen urging Dhawan and Dave to finish arguments within a fixed time to limit their arguments to points that were not made in court before. Though they requested petitioners to complete arguments tomorrow, a swarm of lawyers convinced the bench for more time. Dave will resume arguments tomorrow, August 17, 2023, and petitioners' arguments will complete tentatively on Tuesday next week. Thank you for watching SEO Daily. Visit scobserver.in for a detailed report on the day's hearings. Make sure to follow us on Twitter, where we give contextualized live updates. And you can also subscribe to our daily WhatsApp updates. We promise not to spam you. We'll just start your day off with the most important updates of the day at 9 a.m. sharp.